What's up everyone, it's the Law School Lumberjack here again with another installment of our Contract Law 101 series. Today we're going to be talking about Promissory Estoppel, or Promissory Estoppel. If you've seen my Folks and Beer case brief, you'll understand that in Old England, for a promise or a contract to be enforceable, it had to be accompanied by fresh consideration. So generally and presumptively, promises made without any consideration or for past consideration were unenforceable. Now, that was up until the case of Central London Properties and High Trees House, where essentially Lord Denning comes up with this equitable doctrine of promissory estoppel. So in this video, we're going to be going through what is promissory estoppel, some of the cases that have really defined what promissory estoppel is and when it's available, and also we'll be talking a bit about equity and the sword and shield distinction. So without further ado, let's get into the basics of what promissory estoppel is. So at the very basic level, how you can think of promissory estoppel is it basically prevents someone who promises something and has the other person rely on it from going back on that promise. So promissory estoppel has three key elements, and all three must be met. So I'll go through each of these three criteria right now, but I'll write them all on a title card after I go through each of the three. So the first is that the promise must be intended to affect the legal relationship. And what that means is essentially it's twofold. The promise first has to be clear and unambiguous, and secondly, the promise from a reasonable standpoint has to be expected to be relied upon. So if you see a promise that isn't extremely clear or is completely outlandish, it might offend this first criteria and promissory estoppel might not be available. The second element is that there has to be actual reliance. So you should always wonder, did the person who the promise was given to, or the promisee, rely on that promise? If they brush off the promise and don't act according to the promise, then it might offend the second criteria and promissory estoppel might not be available. The third element is that there has to be some detriment faced by the promisee. So the person has to be worse off as a result of the promisor basically turning their back on their promise. So I'll put these three criteria on the title card on the next screen so that you can look through them. Welcome back. So as I said, promissory estoppel largely comes from the case of Central London Properties and High Trees House. So this case essentially happens during wartime, and the landlord in this case offers his tenant, because it's in wartime and because the tenant might not be able to afford the property, the landlord offers to reduce the rent for a period of time for his tenant. The tenant obviously agrees to that, and based on the strict doctrine of contract law before this case, that promise was unenforceable. But anyways, the tenant agrees and relies on this promise, pays reduced rent, and at some point the landlord charges the tenant an increased rate, or the regular rate that he was charging before, and then asks for back rent. So asks for all the remaining rent that wasn't paid during that period of time when he offered the reduced rent. So this case goes up to the House of Lords, and Lord Denning holds that, again, using these three criteria, there was a promise that was intended to affect the legal relationship. It affected the tenancy. There was actual reliance on this promise because the tenant acted accordingly and stayed in the property for the reduced rent. And thirdly, there was detriment to the tenant if the landlord went back on his promise, in the sense that the tenant would have to pay money he might or might not have as a result of the back rent. So Lord Denning creates this promissory estoppel, this equitable doctrine, in this case, applies it and holds that the tenant doesn't have to pay the back rent, and that the promise to reduce the rent for whatever period of time it was enforceable as against the landlord. So let's go into promissory estoppel in a bit more detail. As I said before, promissory estoppel is an equitable doctrine. So in order for the courts to agree that promissory estoppel is invoked, or any equitable doctrine is invoked, you have to come into court with what's called clean hands. And this comes into play in a case called DNC Builders and Rees. I won't go into too much detail in that case because a lot of that case deals with collateral contracts. But essentially that case, among other things, stands for the fact that if you don't come to court with clean hands, or you act in a way that is inequitable or not fair, then the court is not likely going to grant you the equitable remedy of promissory estoppel. So you might be wondering, how do I apply this in my law school exams? So if you see someone making a promise and then acting in a way that makes you say, oh, that's not really fair, you should be thinking maybe the equitable doctrine of promissory estoppel, while it might legally be available under the three-part test, it might not be available because of the person coming in with unclean hands or acting in a way that is unfair. Now, the final thing that might happen with promissory estoppel in a law school exam or with a fact pattern is whether or not you can use promissory estoppel as a sword. And what I mean by that is, generally, estoppel is used as a shield. So it's an analogy. Basically, the courts use the shield and sword distinction. So estoppel is often used as a shield to protect someone against an unjust claim. So, for example, in the Central London Properties case, it was used as a shield to prevent someone from charging unfair back rents against someone. However, it's questionable whether or not the doctrine of promissory estoppel can be used as a sword, also known as kind of a cause of action to try and get money out of someone. So there's two lines of cases on this thought. One line of cases says that estoppel can only be used as a shield, and one line of cases essentially says that estoppel can be used as a sword, but only in very kind of narrow specific circumstances. Essentially where it would be unconscionable not to be able to use it as a sword. When you're writing a law school exam, it's important to provide a primer saying that the general rule is that promissory estoppel can only be used as a shield, but there are some cases that can be relied on that suggest in certain circumstances promissory estoppel can be used as a sword. So for example, on the one line of cases that say promissory estoppel can only be used as a shield, we have a case like Combe and Combe. Essentially, in that case, the court holds that promissory estoppel is clearly a shield. It can be used to modify certain causes of action, but it can't be used as its own cause of action to try and get money from someone. Conversely, in certain cases like Waltons stores and Maher, the court holds that you can actually use promissory estoppel as a sword if not using promissory estoppel would lead to an unconscionable or unjust result. So essentially, again, when you're writing a law school exam, it's important to point to this distinction, point to the general rule that promissory estoppel can only be used as a shield, but then suggest that there's other cases that can be relied upon in certain circumstances where it might be unconscionable not to use promissory estoppel, and suggest that there is a chance that the court may use those persuasive cases to suggest that the promissory estoppel in the fact scenario might be used as a sword. I hope this video was helpful. If you have any questions, comments, feel free to comment below. If this video was helpful, I'd really appreciate it if you could like and subscribe. Thank you very much. Take care. See you next time.